like to introduce myself to you all and tell you a little bit about who I am, my career track, and then what I do here at BMCC. So my name is Ayana Titus, and my title here at BMCC is the Chief Diversity Officer. I happen to also be an attorney, and what I guess in terms of my background is that I got my Bachelor's of Art from Emory University, and then from there I went to law school at Loyola University, and then I spent some time abroad and lived in the Netherlands, in Amsterdam, and I did a master's program in comparative labor and organization studies. In terms of my work experience, I've mostly been working here in New York City. I've worked for the New York City Department of Parks and Recreation, where I was the Deputy EEO officer there. I also worked at the Department of Homeless Services, where I worked in the General Counsel's office, and I also served as a liaison to the Office of Equal Opportunity. And then from there, that's when I went abroad. I came back. I also worked for an airline company, and you'll see me reference some examples of working in the airline industry. And there I was the Employee Labor Relations Manager. There's some crazy things going on in the airline, I'm just saying. So you'll see me talk about that a little bit. And then I came here at BMCC. As the Chief Diversity Officer, I do a lot of different things, but the majority of issues that I work on relate to discrimination. So people can make a complaint about discrimination, whether you're a teacher, you're faculty, staff, student, doesn't matter. So I deal with a lot of complaints regarding discrimination. The second biggest complaints that I work on are sexual harassment or sexual assault. So if I'm dealing with sexual assault issues, I'll work with student affairs, also with public safety. I'm in charge of compliance and dealing with our search process. So when we're hiring, we have a whole search procedures that we have to follow, and I make sure that we're in compliance with that. I also put together the affirmative action plan, and that's something that goes to the federal government. Part of the reason why we do that is because we're a federal contractor, and I'll just touch upon that a little bit later in the presentation. And then any and everything that the president or someone legal asks for is what I do. I'm a direct report to the president, and my office is in the president's suite. Feel free to visit me. It's not like it's the principal's office. I tell people this because for some reason people shy away from me, but my door is always open, especially if you're interested in HR or interested in the legal profession. I'd be happy to help you. Today we're going to talk a lot about EEO laws, and I saw all these questions that I got. They were very good questions, and we'll talk about that. And I'm one of these people, I'm very informal. As y'all can see, I'm a little bit excited and a little jazzy little character, so feel free to ask questions, relax. I'm happy to be here, and I basically work with Jane, not a lot, but I tend to just tease Jane half the time. Because what I really do is just come in and bother Jane while she's working. So I just feel great to just be here and for her to invite me and have a chance to talk to you a little bit about what I do and the laws that we have to abide by. And I mean, all of this, well, everybody has worked at some point or will work at some point. This is relevant to your everyday life. So with that being said, I'll get started. And set up over here. Oh, BMCC. Oh, no, this is fine. Okay, so I've entitled this Equal Employment, EEO, and Human Resource Management. And today what we're going to talk a little bit about our protected categories, terms and conditions of employment, because you'll see all of these laws apply to terms and conditions of employment, the various anti-discrimination laws, theories of discrimination, like how does someone really make a discrimination claim? Do you just say I've been discriminated against? What does that really look like? The enforcement agencies, and I know you all have been reading about the EEOC, but there's other enforcement agencies I want you to know about. And then lastly, affirmative action and diversity management. So why do you think EEO is important? Why do we even have these laws? What do you all think?
So everybody can have an equal opportunity for a job, regardless of like your race, gender, and so forth.
So everybody can have an equal opportunity. Does anybody have any other ideas?
Just to make sure that everyone is treated fairly, on both sides, the
Right.
employer and the employee.
Okay, so a sense of fairness. Everybody's given some type of equal chance in applying for a job or being considered, or even what happens when you're in an organization. So I would say like to ensure some equality in the workplace, to ensure some fairness, to promote an environment that's free of discrimination, to support a work environment which is really inclusive of all people. So let's talk a little bit about protected categories. I think everybody has heard of a protected category, meaning that the employer can't make a decision based upon a certain characteristic. And so some of the protected categories are listed there for you, like age, right? Race, national origin, sexual orientation, pregnancy. There's a few of them that aren't up here that I wanted to point out. One is arrest and convictions. So that's something that is covered under New York City law. That's a protected category. A couple of years ago, recently, the unemployed became a protected category. Why? Because some employers were not considering people simply because they didn't have a job. See what else is up here. Yeah.
What do you mean by arrest?
So one of the issues is people get arrested, and there are times in the employment process where you may have to disclose your arrests or convictions, right? So is the employer basing their decision on your arrest? But let's say you were arrested or convicted of a crime that was 20 years ago, and now you're applying for something that's totally not related to the crime. Could a person make a claim that maybe they were subject to discrimination based upon disclosing their arrest and conviction record? The answer is yes. That's not something that's protected under federal law, and I'll distinguish between federal, state, and local law, but it is a protected
But
characteristic.
don't those things matter? I believe it's like, wasn't it for like X amount of years?
It,
As far as like now it matters, and if it's recently.
it depends on the job and the time, and there's different factors that the employer has to consider. So you may, let's say, when I worked at the Parks Department, we have recreation centers, and the centers had children. Do we want a person convicted of child molestation or anything like that working at the center, even if it occurred 10 years ago? We may say no. But if we're dealing with a job that's totally not interfacing with kids, we may have a different assessment. So yes, there are different factors that you're looking at, which is why you don't make the blanket decision and say, oh, I'm not going to consider this person or hire this person because of their arrest or conviction. Right? That's just another protected category up there. Yes.
I'd like to know what you meant by unemployed. Like, I mean, I know unemployed does not have a job, but people won't hire you because you don't have a job.
So one of the issues that came up recently in New York City is that there was a lot of long-term unemployed because of the economy, people just didn't have a job, people were laid off. And employers were having these blanket policies where if a person applied and they weren't currently in a job, then they weren't considering them at all. They weren't looking at their resumes, they weren't interviewing them. So what I'm saying now is that it's illegal in New York City to do that. So, okay? Yep.
Is that the same as in, for example, let's say someone that went through high school, college, and never had a job, and then they finally graduate? Is that the same thing or not?
I don't think they're distinguishing between like the employment history or you didn't have a job
Mhm.
per se. It's just more so like you're not currently employed and you're using that as the basis of why you're not considering the person.
Okay.
And yes, I mean, as I obviously as a college student, or you may not have a lot of
Yeah.
employment history. I think that's different than a person who may have been laid off and been out of work for a while, or a person who hasn't been working, then they work for a little bit, then they're not working again, and sometimes people view that in a negative way.
Okay.
So I just wanted to just kind of give you a sense of what is out there that's protected. Does anybody know what color refers to? You hear color, because there's color and race. You know, what does color mean?
Color of your skin.
Right, it means exactly the color of your skin. So sometimes when we talk about two people of the same ethnicity can discriminate against each other. Common thing would be, let's say African Americans, you're dealing with dark skin versus light skin. So color is protected there. So where do these laws apply? It comes up in terms and conditions of employment. So that's basically everything that goes to being employed. So that's your hiring, your promotions, assignments, transfers, benefits. The employer cannot make a decision based upon a protected characteristic in any of these areas that I'm mentioning. So this is just the basics of work when you show up. The other place that the laws apply to is as an applicant, meaning that, well, I said earlier that we can't decide that we're not going to hire someone solely because of their race or gender or certain things like that. And it applies to what happens when you become employed by an organization. So again, the employer shouldn't be making decisions based upon protected characteristics when it comes to your assignments, promotions, and things of that nature. So let's go into a little bit about the law. The one that most people know of is called Title VII of the Civil Rights Act of 1964. It basically bars discrimination, and here is listed race, color, religion, sex, national origin, and pregnancy. You'll see something like sexual orientation is not covered under federal law. That doesn't mean it's not protected. It's just protected usually under state law or city law. You'll see here also that it covers employers with 15 or more employees. It applies to state and local government. There is one exception, and I know your chapter talked a little bit about this, called the bona fide occupation qualification. And that's really the one kind of exception where the employer can make a decision and consider a protected characteristic. So the example I always give is, let's say I am a correctional facility and I am looking for a security guard, and part of the duties and responsibilities of that security guard is they're going to actually have to go into the showering facilities, the bathroom facilities. Is it okay for me to say I'm looking for a female security guard or a male security guard in that scenario? Well, the answer is yes, that's really linked to the job. Likewise, when you think about religion and you say I'm looking for a minister, is it okay to say I like the minister of a certain denomination of the church? Of course, you're not going to hire a priest to run a mosque, right? Right? So religion would be something that you would have to consider in that hiring decision. But let's say I'm applying to be a custodian in the church. Will my religious preference really be linked to the job? No. Do you all see the distinction there? It's a rare exemption, but I just wanted you to know about it because I know it was mentioned in the chapter there. Yep.
To what extent, is an employer allowed to use the bona fide occupation as an excuse? Because let's say, for instance, that the employer has a certain demographic they primarily choose, and then just so happen to use that as an excuse. How are you able to know the difference, right, when it comes to situations?
Well, this is such a narrow example or exception that really and truly, like, if you're saying like you're interested in reaching out to certain demographics because your customers, let's say, are from a certain region and you want people of that region, that's not close enough link, because you could be a person not from that region but has a certain amount of experiences in that region and still be able to do the job. So let's take your example, like modern language department and you want to hire a Spanish speaker or a person who's going to teach Spanish, does that person have to be of the Spanish background to really teach the class? Not necessarily, because there's plenty of people who lived in Spanish-speaking countries or who have studied Spanish enough to be fluent and be able to do the job. So I don't find that employers would use, well, this is a bona fide occupation qualification type of exception. There was a situation, I was at the airline where we were flying to a country where they had strict laws regarding women, and you had to be dressed in a certain way and things like that. And somebody tried to put out an advertisement or put out an assignment kind of email that no female flight attendants could go on this flight. And I was like, but that doesn't make any sense. Even if the countries have certain types of restrictions, that's not close enough linked to the job where you can say only males can do this particular type of assignment. But this is something that is really rarely used, and the one time that it's been upheld is really in gender and religion. So here's something I've been throwing out these little like illustrations because our employees had to go through this online training, like Jane and myself, and it kind of just reinforces some of the laws here. So it says, Faith works at a school daycare center, and Neil has applied for the job working with 1- and 2-year-olds. The center manager claimed that being a female was a bona fide occupation qualification for the position in order to ensure the safety of infants. And so the question is, well, can sex be a bona fide occupation qualification for the job that Neil applied for? He's basically going to work in a daycare. Do you see what I mean? And it says here no, because it says a bona fide occupation qualification can only be used when it's reasonably related to the job duties, and no one in the excluded group can perform those duties safely and efficiently. So stereotype characteristics like a guy can't work in the nursery, you know, and customer preferences, some like you kind of mentioned, do not warrant the use of this exemption. Okay, so let's talk a little bit about the Equal Pay Act. And basically, I know you know that women still to this day, yeah.
Before we move on, as a bona fide occupation qualification, would you state that as what you're looking for in that description, or would?
When you
You
say
know what
this,
I'm saying,
when
like,
you say description, what do you mean?
So, you know how most employers would be like, I'm looking for this, or I'm looking for that. Can you state that in here, or do you have to, would it only be as a defense, like if you were to be held against it?
I would say that that would probably be more used as a defense, because in your job posting, you're not gonna say, this is the bona fide.
Yeah, that's
You're
what
just
I'm
gonna say, oh, this is the job, here are the duties, this is how you apply, this is the salary. But that issue comes up more if somebody's questioning, why did you put female such and such in this job vacancy notice? So the next thing that I put up here is the Equal Pay Act. And I know that there's been a lot of talk about gender equality in our country, yes. And we know that women still don't earn the same amount of money per dollar that a man earns. So the Equal Pay Act is essentially saying that an employer has to give equal pay for equal work. And jobs are equal if they have substantially the same skill, effort, responsibility, and under the same working or similar working conditions. A couple of exemptions to this is that, let's say you have seniority system in place and you've got two people, one is more senior to the other, then obviously there can be a difference in terms of salary. Likewise with incentive payments or merit increases. So here you have an example where it says the Equal Pay Act requires equal pay for equal work. Which of the following violates the Equal Pay Act? A male registrar and a female professor earn different amounts. Probably not, because they're two different types of jobs. A male dean of the English department and a female dean of the law school earn different amounts. That sounds about right, same job, just working in different departments. The last one says a male line chef in the cafeteria and a female cashier in the cafeteria earn the same amount. Well, really and truly, you can see that the deans, if they're two titles, similar qualifications, but they're working in different departments, then it doesn't really make sense. experiences, for instance, so like when people are applying for a job, I've noticed that if you work a certain amount of years and you compare that to someone else who might have been in the organization, sometimes the person who's coming from the outside with a certain amount of experience seems to get a higher salary. I just think it's very hard to prove, and I think there are other issues. I'm gonna get to you, sir, in a minute. But I think there are other issues that are really impacting pay and why it seems as though it's not equal when it comes to men and women. There are definitely issues when it comes to women sitting out of the workforce for a little bit of time to start a family, for instance, and then coming back in. Sometimes that creates, I think, some differences in pay. Sir, you had a question?
Oh, yeah, I was gonna say, yeah, it's kind of hard to tell, like, as far as pay is concerned, because half the time, whether it's an increase or anything that has to do with pay, is usually disclosed information.
Yeah, I was gonna say the other issue is people don't know that such and such is getting paid more than
So,
them.
and the
That's
jobs
the
usually
other.
maybe,
that's
they
the
tell
other-
you before, you know,
Right.
this is disclosure from, and then make it sound, they do it in my job, because I'm a manager, so it's like,
Yeah.
so it's kind of hard to really,
In the public sector, you don't have as many issues, and that's primarily because we're unionized and there's a certain kind of, everybody's getting the same pay, the same type of increases on a yearly basis. There's a lot more transparency in terms of pay, so you have to disclose certain things. In the private sector, I find that it's a little bit more harder to figure out, well, how much is such and such getting paid? That kind of goes to like the Lilly Ledbetter Act that I think the book talked a little bit about. Because one of the things is like, well, after a certain point in time, you only got a certain point, you only have a certain amount of time to be able to file a lawsuit. You know, you can't 10 years later talk about, oh yeah, let me file a lawsuit and say I wasn't paid in an equal manner. And this is essentially saying like, okay, you got another paycheck and it's still you think it's still in violation of the Equal Pay Act. Well, now your statute of limitations, that clock starts again. So then you're able to file a complaint. If you look up who Lilly Ledbetter was, she was working at Goodyear Tire and stuff, and she realized that there was an issue in terms of differences in pay. And by the time she found out about it, well, the statute of limitations had run. And so the question is, well, do you get to make that lawsuit when you find out about the claim, or can you still make that lawsuit, or can you still file that claim knowing that the Discrimination Act is still happening, meaning that you're still getting paid less?
I have a question, something I always wonder. Are employers allowed to ask, like for instance, if I apply to a job and they call my previous job and they ask, well, what was her salary? Is that legal?
Yes.
Okay.
Yeah.
I always wondered that.
Yes, I mean, and the thing is that typically they'll ask you, can we contact your previous employer to get some basic information about you and your salary range and things like that. The one area where I find employers won't talk about is if you were a poor performer or you didn't do so great, they tend to just give real basic information, which is how much you made, what was your title, how long you worked there. Because the minute you start talking about performance, then you open yourself up to either defamation or slander. So most employers, especially large organizations, know not to really get into why a person left and the circumstances around that. But talking about salary, your title, those are just some basic things. And some of that is just when you fill out an application, you kind of got to figure out, is this person lying or not? Let me call the previous employer and find out what indeed was that person's title and how much did they make, etc. Yes. I'm not gonna let him get to the presentation. I can see I'm going slow. I am going slow, but go ahead.
Sorry. So the only way they can ask about your performance would be as a reference, right? Otherwise, if they call it, because when I went to banking, as far as the screening process, they asked for all the people, all the companies that I worked for, but they weren't under like a reference section. So if they're not in the reference section, when they call, they can only ask for how much you were making, like you said, and all those things. They can't really get into your performance, or can they?
Well, I don't know, Jane. What would you say from the HR perspective? Because I find like there are employers that are going to call for your references and things like that, but the basic stuff is.
The basic stuff, the year, the number of years and your salary and your title.
They
That's
can't
it.
ask about your performance.
Because that's.
Most of them will not do that, not from the HR side, but they will contact your references
Your
and talk about.
Yeah, that's what I'm saying, as
in
far as
that
this
scenario.
scenario.
Now, I just don't distinguish or say this is the reference person or this other type of way of getting the information, in as much as who's providing the information is more important. HR people tend to just keep it at a very minimum. A supervisor who you know and had a good reputation with will probably say a lot more.
What about background checks?
So-
Aren't they allowed to answer specific questions when it comes to
Yes,
background
and it
check?
depends, and it also depends on like the type of job that you're applying for and all of that. Not every employer is doing this extensive background check. I know when I worked for the city, they did a criminal background check on me. And I know that when I applied to this position, it went beyond just a regular reference check. It was like they wanted to talk to my current supervisor, past supervisors, and then anybody that supervisor had referred them to, they wanted to talk to that person, so it was a lot more extensive. This is the outside group, the Pauling group, Jane. But it was a lot more extensive in terms of doing a background check and basically seeing if I was kosher or not. Go ahead.
It also included, your degree, your education,
Yep,
as well as.
so what happens is I had to produce my actual degree. I had to give them a photocopy of my law degree, a transcript, and my Bachelor of Arts degree. They may not call it school, that's something that I graduated is in the transcript or usually the actual copy of the degree.
Because in some background checks, they actually go as far as asking if there's disciplinary action taken against you in the school, or if you've been disqualified or something like that as well.
Oh, I hadn't heard of that before. I think really and truly, from my standpoint, it's important to understand if the person graduated and with what degree, and if that degree is something that they're saying on their resume and their application. You know what I mean? Sometimes people put the timeline and what they have. I'm gonna move forward because I'm slow and I'll be talking a lot. The next law here is the Age Discrimination in Employment Act, or the ADEA, and obviously it prohibits discrimination based upon age, and it applies to persons who are 40 and over. So usually when we talk about age or we think about age, a lot of people are thinking about senior citizens, and they're like, oh, you have to be 65 or older to make a claim, but in federal law, it's 40 and over. In New York, though, it's 18 and older who can make a claim of age discrimination. When we talk about age discrimination, obviously it prohibits harassment. We'll talk a little bit about harassment, but harassment and decisions based upon stereotyping. So I think I have another law under the ADA is the Older Workers Benefit Protection Act. And this really comes up when you're talking about severance or layoffs. And essentially what's happening is that there's more sort of safeguards for an older worker. So you have to put in writing that they have a right to consult with an attorney, they have a certain amount of days, it has to be clear. It comes up more, like I said, when you're talking about a person leaving the relationship, the employer-employee relationship, usually severance packages. So let's look at kind of an illustration here. So Margaret, a college sophomore, asked Trina for promotion to head cashier. Trina gives the job to Jacob, a senior in college, because she thinks he is more mature and responsible. Did Trina violate the ADEA? And it says no, because basically the ADEA only protects workers age 40 and older. Does everybody see that here? Rex has been in charge of the stockroom for many years. A little bit of hair he has left on his head has turned gray, and he's wearing some reading glasses now. The other employees joking with him, call him Pops, and sometimes tease him about eating dinner at 4:30 p.m. Now, what should Trina, who's the supervisor, what should she do? The first says nothing, it's all good fun. And Rex chuckles, and when old folks jokes are told. 2, it says ask employees to stop making fun of Rex's age. 3 basically says provide sensitivity training to all employees. So I just bring this up because sometimes when we're thinking about harassment, a lot of times we're focused on sexual harassment, but we'll talk a little bit more about harassment based upon a person's protected characteristics. So you a pregnant person must be treated the same under employees leave policy or reasonable accommodation type of policies where it comes up. So here we have, Akiba is hiring a new employee in the financial aid department. Melissa and Carla are both equally qualified, but Carla is 7 months pregnant during her last interview. What qualifications can Akiba consider? So it says Melissa will work for lower pay because she doesn't have a family to support. The second says Carla has volunteered as treasurer for a small non-profit for the last 3 years. The third says the position often requires overtime, which Carla will not be able to do if she has a child in daycare. Do you all think employers in the back of their heads think about pregnancy? Do you think if you showed up for a job pregnant that you would get that job?
Yeah.
Sometimes? What do you say sometimes?
I mean, it's 50-50 because some people would say no because when you're pregnant, so if they were to hire you today, there's certain things that you wouldn't be able to perform depending on what kind of position you're applying for. And then after you have your child, you know, what if your child gets sick, what if something happens to you, you're calling out constantly, things like that. But then sometimes someone would because it's like you obviously need a job to provide for that child, you know. But I mean, not everybody cares more about the sensitivity part, it's more so business, but I think that there will be, like if there's a mother or something like that who is interviewing you, that part will probably touch her more, like, you know, you have to give out to have a child, you need a job, so, you know, we can work with you, you know, and try to see, you know.
Let me hear from the electrician and then from you.
Well, coming from, I worked in law firms for a number of years, and if I came to the job pregnant and showing, I would not be hired because it would be an attendance issue. Whether they felt, you know, that I needed the job or not, it would be an attendance issue because I'd be out for that period of time, you know, maybe 3 months or 4 months or whatever, just to have the baby and to recover. And that's time that they could be using to train someone else to replace, to fill my duties. So.
I kind of agree with Ivy.
Is this Ivy?
Yeah.
Okay.
Yeah, because I feel like in someone who's hiring you in their eyes, it's kind of like, oh, you have a family, so in a sense, it's not all the way right, but you're gonna work hard because you value this job because at the end of the day, this job is taking care of you and your family, opposed to someone who is devoted to themselves and their personal needs. You could do this and you could go out, you could do a lot, you know what I'm saying? You don't really value this job as much. You know? I feel like that's how I think of it.
Do you all think there are differences in treatment when it comes to family responsibility between men and women?
Yeah.
Do you think men are perceived positively if they have family responsibility versus women?
Yeah, when I first got hired at where I'm working now, one of the things that she asked me was, do you have a family? And she's not allowed to do that.
You were asked, do you have a family?
She was like, okay. And because they were looking for someone who could automatically do overtime. Like it's just automatically required. And but they don't tell you that. So I think, you know, there's a difference between men and women because they're not gonna ask a man.
I was gonna say, do you think they would ask a man
No,
the same
never.
question?
They would never ask him. And regardless whether he has a family or not.
I'd like to hear from someone. I feel like you had something to say because you're smiling. You just turned your head like
Okay.
this.
No, to her point, I think, yeah, employers they play on their part sometimes on what they want to ask you. But it is pretty unfair to ask her if she has a family. I've never heard of that.
Okay. I just wondered what some of your thoughts were in terms of, I know I wouldn't feel comfortable showing up at a job interview pregnant, you know, even though I know that they can't be thinking about that in my qualifications. I just, I'm very practical, I just know that I wouldn't feel good about it. So let's talk a little bit about the Americans with Disabilities Act, the ADA. Has everybody heard of the ADA? Yes. So it basically prevents discrimination based upon disability. It includes the physical and mental disabilities, also having a record of an impairment or being regarded as That regarded as having an impairment comes up when an employer is making an assumption about you, like, this person has this disability, and then is using that as a basis for decision making. So let's say when it comes to assignments, and the employer or supervisor is assuming that you can do certain types of tasks, but they don't really know. So it's sort of regarded as having an impairment is where that comes into play. One of the things with the Americans with Disability Act is sort of trying to define what is a disability. And recently it was amended because there were so many issues as to is this person really disabled or not. It's supposed to be something that interferes with major life activity. And so now we have amendments, American with Disability Act amendments, and you'll see that now they've spelled out a little bit more clearly as to what is a major life activity. And it's helped to kind of put some clarity around what is an actual disability. I will say in New York, that term is a little bit broad, so I never, when I dealt with reasonable accommodation type of issues in the workplace, I never sat and said, well, this is a disability, because really, Julie, in New York, it probably is a disability. So the next really inquiry is, can we offer some type of accommodation? So let's talk about, because it says spot the disability. It says disabilities come in many forms. Which of the following people is disabled? John is a diabetic, he must inject insulin once a day. Tomo suffers from anxiety and sometimes has trouble leaving his home. Zane is addicted to cocaine that makes him hallucinate. So in the front row here, we have somebody saying that being addicted to cocaine is a disability.
It's a disability. Sometimes you can't control it. Like you know.
Okay, let me ask you something.
Don't they consider alcoholism a disability?
Okay, so let's talk about alcoholism. Let's talk about medical marijuana. That's a good one, right? So usually basically illegal drugs are not covered when it comes to the ADA. And I looked up medical marijuana because I was like, well, is that really covered? And really, truly, it's not. You can't show up to the job high and say, well, I'm covered under the ADA, you need to accommodate me. Likewise, there's some employers who have drug tests, like they actually give you a drug test. So let's say you're a driver of a truck and you fail the drug test and you're saying, well, I take medical marijuana or I do cocaine here and there. It's not covered. Now the treatment, like alcoholism and the treatment, and let's say you need to go to AA, that is something that hopefully the employer can help accommodate. That is something that you can work with the ADA on. But just saying your disability is, I'm addicted to cocaine, I don't want you showing up to the job saying I'm addicted to cocaine and I'm covered. That is not covered under the ADA. I'm sure there's smart, talented people, but you gotta look at it. You gotta look at it from the employer standpoint too, and liability issues. So the minute you, let's say, fudge on the policy and not do certain things, and you know that the person would fail the drug test, that person gets in an accident, that person is driving your vehicle, that person is doing something on the employer's time, then that's going to be a concern from the employer's standpoint. You were just stretching?
I was stretching, sorry.
Really? Because I thought you were ready to just knock me out with some knowledge. Okay, I'm going to call you though later because you were stretching and I felt like you had something to say there. But anyway, the bottom line is illegal drugs are not covered when we're talking about disability, whether or not a person should be accommodated. So let's talk about reasonable accommodations. Yes, Ivy.
When it comes to the accommodation, like you were saying, I mean, of course, it's not about what I agree with, but I would personally, as a manager, rather accommodate someone who would come, not on cocaine, of course, but who had medical marijuana, something like that. Then medical marijuana is actually prescribed to you. That's something that I that's something I would accommodate versus an alcoholic, someone who's coming drunk every day, that wouldn't make, you know what I'm saying, like.
I know, you probably shouldn't use those kind of distinctions in terms of why you would accommodate. That's not the analysis that we're looking for. So first you gotta understand, is this person disabled as covered under the ADA? The second question is, can I offer some kind of reasonable accommodation? Meaning like basically modify work schedule, restructuring jobs, making certain things accessible. Is there an undue hardship in the accommodation? That's the third kind of question you have to ask, because there are certain things you can't accommodate. If a person can't do the essential functions of their job, you can't accommodate that. If it's gonna be unduly burdensome on the operations of the organization, you probably can't accommodate that. Is it too costly? You may not be able to accommodate that. I feel like you have something to say.
If a person is smoking weed, Ivy, and they can't get up in the morning to get to work on time, they are not covered under the ADA.
I mean, I'm not saying I can't get to work, I mean, I know people,
Oh.
and not me, of
Yourself,
course.
there's absenteeism, there's attendance issue.
But there are people who get up drunk and can't go to work, who are drunk and can't go to work. I'm being,
That's all.
people who do marijuana are functioning.
Well,
Yeah, they know how to function under their influence.
But the other thing is too, I remember I worked with someone and she was an alcoholic. And so
Right.
what she needed to do to get to work, she was there every morning on time. But her pores, the alcohol would come out of her pores and there were complaints from the other staff members. So she wasn't covered underneath it, but as her employer, I had to speak to her about it and recommend getting her help. But she's not covered underneath that. If she didn't get her act together or go to AA or whatever she needed, she needed to get fired.
So in reality, is AA covered under the?
no.
Oh, that's why
I heard what you were saying, but look at what it really refers to. A person with a disability is someone who has a major physical or mental impairment that substantially limits one or more major life activities. So let's think about alcohol and marijuana. Is that a major life activity? Look what they're listed as major life activity. Being able to see, being able to hear, being able to breathe, being able to learn, being able to be drunk, being able to be high is not probably a major life activity if you sat and thought about it. But the questions that you should be asking as a supervisor is the person disabled? Is this something, can they perform essential functions of their job? Is there an accommodation that we can give them? Is it going to be an undue hardship? Those are the kind of questions that you want to get into with your human resources. Not, are you?
No, I got it. I just
All
thought
right.
that, I guess what I thought that you were saying was that AA was under, that's why I wasn't getting it.
Well,
So to me, it
the
kinda threw me
treatment of
off.
alcoholism is something that's covered. So if you're going to AA meetings and it's not an undue hardship, then the employer can accommodate that. You know, that's the distinction there. So let's look at undue hardship for a second. And it says undue hardship is an accommodation that causes significant difficulty or expense. So undue hardship considers the nature and the cost of the accommodation, type of operations, the impact of the accommodation on the operation, financial resources, size, number of employees, and location of the organization's facilities. I'm going to go on here. So Jillian is an assistant in career services and she's got multiple sclerosis. The pain in her legs makes sitting for a long period difficult. Jill asked for a special ergonomic chair that costs $9,800. Dean Harrison found a similar set for half the price. Now, does Dean have to purchase the desk and the chair that Jillian asked for? No. I mean, of course, it says no up there, but do you all see the reason behind it? Because really, you know, you're asking the employer for the accommodation. The employer can say, hey, we could do something else. They're not obliged because you want a certain type of accommodation to, you know, basically go with what your recommendation is. So it says here, no, if a less expensive set provides the same relief, no, the employer can choose the best accommodation. Let's talk about GINA, which is the Genetic Information Non-Discrimination Act. It basically prohibits discrimination based upon genetic information. Now, I have not dealt with any type of GINA issues in the time that I've been doing this, nor have I seen a lot of litigation around it, but I do want to highlight something that we got in our online training here. So this talks about the need for GINA, and it says in 2001, the EEOC settled the first lawsuit alleging genetic discrimination. And here it says a national railroad company secretly tested its employees for rare genetic conditions that causes carpal tunnel syndrome. The railroad claimed that the testing was a way of determining whether the high incidence of repetitive stress injuries among its employees was work-related. So the company paid doctors also were instructed to screen for several other medical conditions such as diabetes and alcoholism. The employees were not told that they were being genetically tested, and one employee who refused testing was threatened with possible termination. I don't know of too many other GINA lawsuits that are out there, but just keep in mind that the employer shouldn't be making any type of employment decisions based upon genetic information. So it says here that Reginald's taking time off to care for his father who's suffering from Huntington's disease. Connie tells Reginald's co-workers about Reginald's father and says that she hopes Reginald doesn't develop Huntington's disease since it's genetic. Did Connie handle the situation properly? Says yes, she's concerned for Reginald's well-being. No, Reginald doesn't want his co-workers to pity him. No, GINA requires her to keep his information confidential. So some of the issues, and I'm sure Jane, are you going to talk to them about like FMLA and
Yeah, we have
those
it.
types? So you guys understand sort of sometimes you have to disclose certain medical conditions in order to get certain types of benefits from the employer.
It's in the later chapters.
Oh, okay.
Let me ask a question. So my job requires that everyone take a physical, because now they are getting into their own insurance, like through the hospital. So, and because of weight and diabetes and things like that, your insurance will go higher because we're group, your insurance, depending upon what your, are they legally allowed to do
I
that?
have never heard of that before, so I would have to probably look it up and find out and get back to you. If that's okay. If you can email Jane that question, and then I can respond to it. Because that's the first time I've ever heard a physical being done because of insurance purposes. Have you heard anything different?
Well, the book talked about new as a new emerging
Right.
issue, discrimination issue.
Right.
And it's all because of insurance policies.
Yeah, I saw that in the chapter where it mentioned that. Let's talk briefly about the military, and this is Coursera. So we've got a lot of people who are in Iraq, Afghanistan, and different places. And then the question is, well, they've been holding some civilian jobs. What happens to those jobs? Can they return back to those jobs? It's not their fault that they've been deployed. So this basically protects that. It says it covers all military personnel. Basically, they can return back to the private sector jobs without risk of loss of seniority or benefits, and it prohibits discrimination based upon military obligation, job retention, and advancement. And so some key kind of facts about USERA: the person had to have a civilian job. The person must be given notice to the employer that he or she is leaving the job for service in the military. The cumulative period of service must have exceeded 5 years. The person must have been released from service with honorable conditions, and the person must have reported back to the civilian job in a timely manner or have submitted a timely application for reemployment.
I have a question about you, Sarah. So, say for instance me, I'm working as secretary or whatever, and then I get called off duty in Iraq, Afghanistan, or whatever. It's been 5 years, and something mentally happens to me, and I come back to my job, and my employer notices that there's something wrong with me. Like, how is the employer protected? Like, you know what I'm saying? Like,
Yeah, because that to me raises up, that might raise up some ADA concerns that the employer has to think about. And then the other piece of it too is, let's say you might not be suitable for that particular job because
Right.
of what's going on. Is there another job? And that might raise you, Sarah, in a different kind of way. Can we restructure the job and you can still do the essential functions? So I think it's gonna, it's like two-pronged analysis and looking at two different types of laws. Because the bottom line too is that if you come back with something and you're harming people or you're a harm to yourself or you can't do the job, I mean, the employer's not gonna sit there and say, well, we have to keep this person because they were in the military. I don't see that being,
I mean, but is the
obligation that
employer
they have.
protected? Like, if me as an employer, if I notice that the person is like a little off,
Mhm.
and I say, you know what, this is not gonna work out, I have to fire you, and then that person comes and files a discrimination lawsuit, like how,
I would see before I would even go through and say you're off. Would I advise
so I mean in a
supervisors?
nice way.
I know what you're saying. So a couple of things. I always advise supervisors that whatever behavior that they're seeing, it has to be job related. So you could be a little bit off, but still be able to do your job. So if we're dealing with somebody who's off, but they can't show up on time, they're off and they can't actually perform their job, then as a supervisor, you have to document that. You kind of have to have another discussion with the employee. Is the person having like a little meltdown? We all have meltdowns every once in a while, and you need to recommend that they go to the employee assistance program or seek out counseling. That's a different discussion. You want to try to make sure you understand the distinction between the two, and I would say if this is a valued employee, you want to see that you've offered counseling to this person, you tried to work with whatever the issues are, you documented certain types of issues. So does that kind of answer how you would maybe think about that? It's a good question because there are some things that happen when we go abroad, and you want to make sure that the person can still do the job and whatnot, and that they're somehow the other issues are being addressed. What I want to turn to now is what we call theories of discrimination, or basically conduct that's prohibited. And I also look at it as, well, how does a person really file a lawsuit? Do they say, I just been discriminated against? What does that mean? How are you discriminated against? What did the employer do? So the first theory we're going to talk about is disparate treatment. And that's basically intentional. And I'm going to be honest with you, I don't see a lot of disparate treatment, meaning that the employer is saying, I'm treating women one way, I'm treating men another way, I'm treating blacks one way, I'm treating whites. I don't see that as often. And you see here, protected class members receive unequal treatment in comparison to someone who's similarly situated. It doesn't come up to me that often in terms of people filing a lawsuit. The second one is the adverse impact, which is unintentional, and I think the chapter touched upon this. And this is where impact or practice really adversely affects a protected group. So I always think about a policy such as height requirement or weight requirement or lifting requirement, and the only people who seem to be able to do it are men. The only people who seem to be able to pass the test are a certain group of people. That practice, even though it's unintentional, is linked to what you're talking about in terms of the job, but somehow it has a negative impact on a certain group of people. So here we have Ursula reports that her employer is making all editor candidates pass a test. One question test for color blindness. 40% of the male candidates have failed that question, while only 8% of women have failed. Ursula's employer didn't intend to rule out more men than women, but is concerned. Is the test proper? And it says no, and it says that discrimination need not be intentional. The pre-employment test affects one of the protected categories of people more than the others. Employment decisions may not be made based on these test results. So you got to think about when you're having a policy, even if it's not intentionally impacted or geared towards a certain group, if the impact is there, then that's going to be a problem. The third is harassment. And I tell you, I hear this word all the time. People are like, I've been harassed, I've been harassed. Okay, so let's talk about what happened when you say you've been harassed. sufficiently severe, pervasive, creates an intimidating, hostile, offensive work environment, and it interferes with your ability to do your job. So sometimes I get people who are saying, and I'll say this with harassment, and I know we talked a little bit before, harassment is not just limited to sexual harassment. You can harass somebody based upon a protected characteristic. One of the big cases that came out was after 9/11. A lot of Muslim employees were being harassed on their job. People were making fun of Muslims all over the place. So when we think of harassment, it's not limited to just sexual harassment, and it's also not the time when you and your coworker just didn't get along and you're upset. Oh, I'm being harassed. That's not it either. It's really conduct that's offensive and really interferes with your ability to do your job. So here, Charlotte is the intern at the zoo, and Maxine, the head zookeeper, assigned Charlotte to redesign the arrangements of the ant farms. Charlotte's deadline is Friday, but on Wednesday, Maxine has asked her 4 times about the progress of the project. Now it says here, is Maxine creating a harassing work environment for Charlotte? And the answer is no. Illegal harassment must be based upon a protected characteristic, but also to the woman's just asking about the project. So there are times when you think about people who are bothering you in the workplace. It's not necessarily, doesn't necessarily constitute harassment. Does everybody understand that? Because there's harassment based, and I will ask somebody, when you talk about harassment, are you talking about somebody's harassment based upon a protected characteristic or somebody's bothering? Those are 2 different things. Doesn't make it right if they're bothering you, so let's say that, because some employers do have like employee code, behavior code, so conduct that's unbecoming or conduct that's not professional is still a problem. It may not be protected when it comes to EEO, but it might violate an employer's policy. So let's talk a little bit about sexual harassment. Have you all talked about sexual harassment already?
Yeah.
Kind of, yeah. In this class or just in general?
In the class, we just mentioned it.
You just mentioned it. So sexual harassment and sexual assault, especially in the higher education context, has really been talked about a lot. If you all been keeping up with the news, it's just a lot of universities have been under a lot of scrutiny as to how they've been investigating and looking into student complaints around sexual harassment and sexual assault. I want you all to just have a basic understanding of what it is. It's unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. There's 2 types. There's quid pro quo and hostile environment. Quid pro quo is a this for that, so it's basically an exchange, somebody saying that in order to get a certain type of job, in order to receive a promotion, in order to get an A, you have to perform some type of sexual act. Hostile environment, which is the one I see a lot, is basically the kind that has the purpose of interfering with your ability to essentially do your job. It's an intimidating, hostile, offensive environment. I put a slide up here, so some things to consider and think about. One, is not limited to the workspace. So a lot of companies have a holiday party, the little holiday party. Everybody's got the little holiday party. A lot of times, well, the policies that are in the actual work environment apply to the holiday party. When I talk to students, I say our policy concerning sexual harassment applies to the student-related activities, like at the basketball game, for instance, or you guys go on a student trip to a certain location. When I worked at the airline company, pilots and flight attendants tended to think of the airplane as their office, and then once they got off the plane, it was free for all, and I had to explain to them, the company is paying for your bus ride, we're paying for a hotel, you're still basically on the job working, so our policies apply there. Sexual harassment can be same-sex sexual harassment, so sometimes when I say sexual harassment, someone's like, yeah, that's when a man is doing something to a woman. So we know that sexual harassment includes male to male harassment as well as female to female. The third prong is that it has to be unwelcome to the victim. So a lot of times people are like, well, I didn't intend to do anything wrong. But what we're really doing is looking at it from the victim's perspective. Is the conduct unwelcome to that person? We're not necessarily looking at intent. Like when you think about criminal law, you got to think about the mind space of the person who perpetrated the crime. It's very different in sexual harassment. We're looking at what did the victim feel? Was the conduct unwelcome to that person? And then the last part is like physical touching is not required. So sometimes people think of sexual harassment, they're like, oh, she touched me, or he touched me, and all of this other stuff. And I try to tell people it's expanded so much more beyond that, because if you think about technology now, I get students coming in showing me their text messages that they received on their phone from somebody who's been bothering them. People love to bring up their Facebook accounts now and show me the type of communications that occur between another person. In the airline, I had a situation where a flight attendant had a situation with a pilot, and they went on it on Facebook. But now they have to fly with that person. So I always try to tell people, like, well, maybe this happened off the premises. Maybe you weren't in the airplane. Maybe you weren't in the cubicle. But really and truly, you have to think about outside conduct that that can impact basically the workplace. The other thing that I always tell people with harassment, I mentioned what is called a third-party complaint, where, let's say the two of us are having a conversation, it's of a sexual nature, we're equally invested in the conversation, nobody's bothered by the conversation, but Ivy's sitting right here and she's got to work in the same work environment. And the question is, Ivy's not a part of the conversation at all. The question is, can Ivy make a complaint that she's been sexually harassed?
Yeah.
Does everybody see why she can make that complaint?
I am offended. I'm gonna do it.
Okay. Somebody, do you see what I'm trying to say? Because, I'm getting a wrap it up sign, But do you understand what I'm trying to say? And it also includes just race. I had a situation at the Parks Department where this person was using the N-word, speaking to another colleague, just talking about a story. And then another person was there listening who was so offended by the conduct. And he wasn't privy to the conduct. He wasn't in the conversation, but the person had to work. So it's just thinking about, again, harassment in the work environment and hostile work environment. Is it offensive? Are people doing this on a day-to-day basis? Things like that. The last two are retaliation, and that basically prohibits the employer from taking. Well, let me do the last two, James, and then I'll take questions. Let me just say the last, because James like, you got to go. You got to go. I'm sorry, Jane. I got to say the last two things here. It protects people who make a complaint, who oppose discrimination, or people who participate in an EEO investigation. So the idea behind it is that